We turn to the last case on this morning's docket. That is case number 109512 in the matter of Susan L. Bowman, respondent.
May it please the Court, Kate Baird appears on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, may I reserve 2 minutes for rebuttal should it be necessary?
2 minutes is granted.
Thank you. The hearing panel considered this matter in discipline against the respondent in January of 2013. At the time, they issued their report about 1 month later. That was 4 years, 3 months after Tyson Langdon died in a car accident. The court is familiar with this case, I know. The hearing panel concluded that the respondent had engaged in multiple instances of professional misconduct in her efforts, or should I say lack of effort, on behalf of the estate of Tyson Langdon and as guardian ad litem for the young man's young daughter. The respondent stipulated to the facts and rules violations as they were alleged in the complaint. She appeared at the hearing and requested public censure. We requested a 12-month loss of license, and I renew that request of the court today. The hearing panel recommended a 12-month loss of license, but indicated and recommended to the respondent that she immediately implement a plan of probation. And should she demonstrate that that had been implemented prior to oral argument, that this court consider suspending 6 months of that 12-month suspension in lieu of a 219 hearing. The respondent has provided our office and the court with an affidavit indicating that she has engaged with a mental health individual. She's engaged a lawyer to assist her in practice supervision. I would suggest to the court that there are several reasons that warrant a conclusion by the court that 12 months is the appropriate sanction, a 12-month loss of license, and a 219 hearing. Those reasons include, first of all, the panel concluded and the respondent admitted that she engaged in conduct involving dishonesty. This court has repeatedly indicated that probation is not appropriate in matters where dishonest conduct is involved. It doesn't take care of that problem. The case in this, the underlying matter here, if you look at the big picture, Tyson Langdon died October 18th of 2008. He was 22. He had a very young daughter, a 2004 Grand Prix, and a job that gave him a life insurance policy. That's what the 22-year-old died with a daughter, a car, and a life insurance policy. The estate was still open when his father asked our office to become involved more than 3 years later, saying, it's still open. This matter needs to be closed and I need your help. The conduct on the day, at the time, at the date of the hearing, the date when the report was issued, and today remains inexcusable and inexplicable. The respondent testified that she was depressed at the hearing. The hearing panel did not conclude that there was a mitigating factor that the depression contributed to her misconduct. They found that the respondent testified that she was depressed, and that she testified that the depression contributed to her misconduct. We do not know that. I would submit to the court that a 12-month suspension and a 219 hearing would allow that particular issue to be addressed more fully by a 3-person panel. And I would ask the court to direct this respondent to appear at a reinstatement hearing and demonstrate to a panel how she has addressed the issue that contributed to this particular misconduct. The other issue...
I'm confused about your statements about the mitigating factors with the depression, because the paragraph 62 of the final hearing report says, in reaching its recommendation for discipline, the hearing panel in this case found the following mitigating present, and then paragraph 64 says the respondent suffers from depression. Am I not understanding your argument, or am I missing something?
Well, I would refer the court, and I'll find it here if I may, in addressing aggravating and mitigating factors at 64, the panel, in addressing personal and emotional problems if they have contributed to the violation. The respondent suffers from depression, and the respondent stated that her depression contributed to the misconduct.
So you're saying, even though they make that statement in paragraph 62, we have found the following mitigating circumstances. You're saying that because they didn't say we find the causal connection, we just are attributing the causal connection to the respondent, that they didn't say enough, they need to go one more step?
What I am trying to suggest is that they considered the fact that she was depressed, and that she stated was depressed, that she was depressed, and the depression may have contributed to her not being able to pick up the file, but that she was the one who had taken the next step to say the misconduct occurred because of the depression. And what I would point out, and maybe as an example of what I'm trying to suggest, is at the hearing there was testimony presented that there were instances where the respondent could actually and did actually take action with the file. There are very few demands made of the estate. And there was an instance where she wrote out checks because the court had directed her to satisfy claims. So she wrote out checks to two of the individuals, or to satisfy two of the claims, but did not write a check to Ted Langdon, did not satisfy his claim. It had been ordered by the court. These claims had been, the court had directed that they should be satisfied. She had the file in front of her. 2 checks were written, 1 was not. That was not a matter of not holding the file or being able to open the file. That was not a case of her just not wanting to deal with that particular matter. But she didn't write that check to a person, to Ted Langdon. And it's my position that we have not been able to, nor has the respondent provided any evidence that her depression, or how the depression kept her from writing that check to the person, to Ted Langdon. There was something personal there, and she couldn't explain it at the hearing. She had no explanation why when the file was open and when she had her checkbook out, that she could write two but not the third. And that is where I think we have a risk, because we don't know who the next Ted Langdon is that might come into her office. I have no doubt, based upon the evidence that's been presented, even as recently as within the last week or two, that she suffers from depression. I'm not sure any of us really understand why that or how that contributed to her inability to deal with the one person. So that was the point that I was trying to emphasize. I'm not sure we have the full picture yet. I think that a panel hearing for the purposes of reinstatement and determining whether or not we have that information would be valuable to the court and to the public.
Counsel, if you're finished with your response and Justice Slicker's finished with her question, I had a question on a different issue, and I'll ask you and also the respondents' counsel to make sure I understand what the impact of the hearing panel's final report says. It seems to be greatly summarized that if her probation is successful, my question is she then actually suspended from the practice of law for the first 6 months during that period of time? You're advocating for 12 months at the hearing and again today.
Yes.
And the panel said, well, 12 months, but if after 6 months she is successful, then we will, from what I could tell, she's only suspended for the first 6 months?
Yes, that she would be reinstated on probation, and because they recommended at least 2 years, I was reading that as a recommendation that the court allow her to be reinstated without a 219 hearing on probation for a period of time. That's the way I understood the recommendation to be.
And if that's correct, what is the practice supervisor, Attorney Klepper, supervising during that first 6 months?
Well, that was another point I was going to make in support of our position that a 219 hearing would be required, because we really don't know what would be happening in that 6 months. And how do you monitor a practice if we're directing a lawyer to not engage in the practice of law? How can she maintain and implement this plan? I think as a practical matter, it would be we would be able at a 219 hearing through a 219 hearing to have panel members address her preparedness to resume the practice of law. But I agree, as a practical matter, if she's not practicing, it would be very difficult to see what if any progress is being made.
All right, thank you.
But that is the way I read it. There was a 12-month suspension. It really appeared to me to be a recommendation of a suspension and that a probation plan in lieu of a 219 hearing. That we end up with a 6-month suspension and then move immediately into a probation period with that 6-month still looming out there in the event there was a violation of probation. It's our recommendation that this conduct, this very long period of time of inaction, of misrepresentation to the court, and disregard really for the family of the young man, that the court find that the conduct warrants a 12-month suspension and then allow a panel to address her preparedness to resume practice at the end of the 12-month period. Unless there are other questions,
Any further questions of counsel?
I'm confused about the recommendation of the panel on the probation plan and the disciplinary administrator's involvement with it. As I read, the panel's report was immediately upon receipt of this, they're supposed to put a plan in place and provide a copy of that plan to the disciplinary administrator. The plan that we got recently indicates that it's what it says is the essential elements of the plan have been in place since prior to the hearing. I guess my first question is, was this given to your office immediately, shortly after the hearing panel report?
That was not, but a version of that was. And in all fairness, the respondent through counsel was communicating with our office in an effort on behalf of his client, certainly, and it would appear by all accounts the respondent providing our office with information on what she was doing in order to comply with the recommendations of the panel.
Do you agree with the statement in the first paragraph of the probation plan overview that says that the essential elements of the probation plan that are set out have been in effect since December 7, 2012?
May I ask the court again, as I grab this to refer
the way it's given to me, or given to the court, it was Exhibit 1, which has a proposed probation plan overview. And in the first paragraph of that document, at the end of that first paragraph, it says the essential elements of this proposed probation plan have been in effect and in place since December 7, 2012, and then it lists out elements of the plan. I'm just wondering whether you agree that they've been in place. The essential elements of this, however you would define that, would you agree they've been in place since that date?
I agree that she has been engaged in the process since that date. I was provided some information, and I through counsel, a report from a doctor, and I followed up with counsel saying, I would always prefacing my comment with, we're objecting to probation under any circumstance, but given the fact that this recommendation has been made, I communicated that I thought it would be appropriate to get some additional information. So there was certainly an effort on behalf of the respondent to provide us with what she perceived to be compliance. There were instances where I advised Mr. Ambrosio that I thought it would be appropriate that perhaps she get clarification on certain things. She has been engaged since very shortly before the hearing. I don't know if that provides sufficient response.
Any further questions of counsel? Thank you, counsel. Could you start with an explanation of my question? And I was trying to paraphrase paragraph 73 of the panel's final report.
Were you talking about the 6 months?
Yes, I was a little confused on that.
First, let me, for the record, so Carol doesn't know, John Ambrosio on behalf of the respondent, and I will be happy to start there. I believe I know what my interpretation is. I think the panel said she should be suspended for a year for this conduct, but if within a short time after the panel report coming out, she has a formal probation plan in effect, then it should be a 6-month suspension, and then she should be on probation for at least 2 years beyond that. That's how I interpret it.
Okay. And my question is, if in fact she is on suspension from the practice of law for a minimum of 6 months, what is the practice supervisor, Attorney Klepper, supervising during that 6 months?
He won't, Mr. Chief Justice, but let's not forget that KLAP is involved in that, and the most important element of this probation plan is the supervision and monitoring by KLAP.
I understand that, but the probation plan indicates Mr. Klepper's been supervising her practice for a while now.
That is correct.
So if I understand what you're telling me correctly, when she would be starting the suspension of her practice of law, he would step aside. If all goes well, she gets her suspension suspended after 6 months. Then does he move back in to resume supervising her practice that is resumed at that time?
Yes.
All right. Okay.
Yes. And I think we have to look at the context of what happened in this case. And I agree with everything my colleague has indicated. Everything she said was accurate. What happened in this case is that this disciplinary case has saved my client's life. And that's, I know I'm histrionic and I'm overly dramatic all the time, but it saved her life. The disciplinary administrator's office calls KLAP, and I don't remember if it was my colleague or Stan or somebody else, calls KLAP, Ann McDonald drives to her office and finds a woman who was obviously not able to move, not able to practice, not do anything, had not opened the envelopes from the disciplinary administrator's office, had not opened the initial complaint filed by the complaining party, had not opened the formal complaint. She was unable to do it. At that point, Ann McDonald got her involved in some type of therapy, sent her to a resiliency group or a therapy group to get her motivated, figured out that she was depressed, got her on medication. The woman who presented herself in my office before Thanksgiving of last year could not and should not have been practicing law. The change between that November meeting and when we had our hearing early January was measurable, but still, I didn't feel as an officer of the court that I could have presented a probation plan at that time because she could not have practiced even with the practice supervisor. We were still identifying her problems. We didn't know about the anxiety. The depression was getting better, the medication had kicked in, but she still was just barely able to put one foot in front of the other. So I think the panel heard that. They heard what she said, that she had made some mistakes, and they were egregious, as my colleague has pointed out, but she was making progress. I believe that the panel said, this is a woman who's never been in trouble before, who is depressed, who may have other problems, and the process has just started. And they said, if we can get a probation plan in effect, by the time we get to the Supreme Court, if her practice is being supervised, if we're figuring out what is happening as far as her depression, her anxiety, and other issues, then she should be given a chance. I think that's what the panel was trying to do. And again, this was egregious conduct. And what she has done since Ann McDonald appeared in her office is to work on her depression, work on her anxiety, work on understanding what it is to practice law. As soon as I got that report, we tried to get a probation plan in effect. And by probation plan, we already had the KLAP portion in, but the practice supervisory portion of it in effect. We got that plan. I sent it to my colleague, Ms. Baird. She made some suggestions. We made those changes. Then we had a real problem finding somebody to supervise her practice. That took close to 45 or 50 days to find somebody who was willing to supervise her. Finally, we found somebody who was willing to supervise her. We Skyped, we talked about what we were going to do. He got involved in her practice from about January 1st and has been supervising her since that date. The change in this woman and my client has been utterly measurable. The woman who will address you today could not have done that, didn't do it at the hearing, and could not have done it when she appeared in my office before Thanksgiving of last year. She couldn't move one foot in front of the other. I was scared every time she left my office at a conference that I was going to get a call from her husband or somebody else that she had committed suicide. I don't mean to embarrass you, but I was scared about that every time. Every time we had a conference. I don't have those fears anymore. And I think the panel is saying to you, this is a person who's a bright person who made some terrible, terrible, terrible mistakes, but I think we can save her, and I think that's what she's trying to do. And if you read my submission, the probation plan, the KLAP monitoring agreement, but what's most important is the fact that my client has been working with a psychiatrist and a JD for a long, long time and is making great inroads. She drives to Topeka, an hour and 45 minutes, one time a month to meet with that Topeka Resiliency Group, which is a wonderful group from what I've been able to determine. They meet in that group for an hour to 2 hours. She comes early and meets with the facilitator, the shrink in that group, and talks about her problems. Ann McDonald was here earlier today as a support person. KLAP has worked with my client in a way that I think has saved her life and will save her as far as a lawyer in practice. I understand why my colleague thinks 1 year is sufficient. I just say, look at the panel report. There's a reason why they looked in her eyes and said 6 months is sufficient. There are no major problems with her. That's not fair. They did say there were major problems with her, but we can fix those major problems with KLOC monitoring and with a practice supervisor.
What was going on in her practice with other clients at the time the complainant had his complaint? One of the observations Ms. Barrett has is there's no explanation as to how her depression and anxiety kind of manifested itself with this one case, but not other cases. Is that accurate, or
absolutely accurate? And no, I don't know the answer to that, Justice Rosen. I don't know, and I don't know if there was conflict in this case. I remember my client, saying to me that there was some conflict between the parents of this child, and there was some yelling, and there was some battling, and she just closed down, is what she explained to me. I don't know. I'm not a doctor. I don't know what was happening. She seemed to have handled every other part of her practice, but on this one case, she seemed to close down. I don't know the answer. And it has never been explained to me in the letters from the psychologist or anybody else as to why. I wish I had an answer for you, but I don't. I'm sorry.
I was going to ask...
I'm sorry. I keep thinking Theodore Roosevelt every time I see you, Your Honor. I'm sorry.
You talking to me?
Yes. No.
Just checking. Would you care to address the point raised by opposing counsel about the board failed to make a finding that any of this was caused by her depression? They didn't go that far. They seemed to say something like, in paragraph 64, she suffers from depression. The respondent stated that her depression contributed to the misconduct. Any response?
In fairness, they really didn't say that it contributed to what caused the problems in this case. I think they kind of said it, but they really didn't make a direct remark that said, this conduct was caused by her depression. And frankly, they couldn't make that because I had no evidence to present at that time. We didn't have the wherewithal. Now, looking at it, when you look at the reports backwards, Mr. Chief Justice, what else could it be? But they didn't make that statement or that comment. With your permission, my client would now like to address.
Certainly.
Come on, Susan. Go ahead.
May it please the court. Good morning. Thank you for the opportunity to speak before you today, although I apologize for the circumstances that bring me before you. I want to give you a brief biographical overview, background of myself, an overview of my practice in Seneca, the reasons I can now see for what caused the disaster that brought me here, and finally, the reasons why it won't happen again. I'm Susan Bowman. I've been practicing an attorney in Seneca, Kansas for 25 plus years. Before that, I was an associate in a law firm in Lincoln, Nebraska for 5 years. I'm the oldest of 4 children, the daughter of a high school chemistry teacher and a high school librarian. I graduated from Columbus High School in Columbus, Nebraska, and attended Doane College in Crete, Nebraska. Graduated with a BA in German, minors in English and Spanish, with a high school teaching certificate. I substitute taught for 2 years after graduation and worked part-time in a law office. And it was in Mr. Beckner's office I discovered that the legal profession was more than Perry Mason courtroom drama. He encouraged me to take the LSAT and apply to law school, and I attended the University of Nebraska Lincoln Law School and graduated in 1981. My husband David and I met and were married during our undergraduate years. We just celebrated our 40th wedding anniversary in August. After I began work with the law firm in Lincoln, he started dental school at the University of Nebraska and graduated in 1985. After graduation, we looked for a small community where we could both practice our profession and raise a family. That community was Seneca, Kansas, population about 2,000, located 75 miles northwest of Topeka. It's the county seat of Nemaha County and lies in the 22nd Judicial District. I was admitted to the Kansas bar in February 1987 and opened my office in 2 empty rooms at the back of my husband's dental office. In 2000, we bought a building that was a medical clinic for his dental practice and built an addition onto it for my law office. We've always shared a waiting room and a front desk receptionist. Our son Thomas was born in September 1987, and our daughter Lauren was born in September 1989. My practice started very slowly and was on a part-time basis until the children were in school. When my children were in school, I was very active with their activities as a leader and as a coach, and I've always believed in being active in my community and served on various boards and commissions throughout the years. I'm currently and have been a member of the Seneca Housing Authority Board since 2001, School Site Council since 2000, Church Board of Trustees since 1992, Nemaha County United for Youth since 2007, and our Seneca Business Women's Club since 1987. In organizations relating to my law practice, I've served since 2001 and continue to serve on the Juvenile Corrections Advisory Board and the Community Corrections Advisory Board. And I've been the Law Library Trustee for Nemaha County since 1994. Besides my law practice, I've always had a small part in management of my husband's dental practice. While he was in dental school, spouses were given a class in assisting because we were told that we would be called in to assist for evening and weekend emergencies, and I've used that often over the years. When the person who did the payroll and bookkeeping for the dental practice, who was doing it in green ledger books, retired in 1992, I took over the accounting and payroll with software on my computers. And when the dental office adopted dental practice management software in 1995, updated in 2004, I assisted with the program selection and was trained on the software. I've always been the backup person for his practice of last resort. If an assistant or receptionist was sick and the secondary backup was unavailable, I've filled in. My practice in Seneca has focused around real estate, probate, corporations, and estate planning. Although I filed a few divorce cases and other litigation in my first years of practice, in the last 15 years, my appearance in district court has been limited to non-adversarial types of practice, like name changes, expungements, and quiet title actions. In the magistrate court, I do estates, guardian conservatorships, determination descents, and adoption proceedings. My name is on the court appointment list for juvenile cases, child needed care cases, and care and treatment cases. I was able to maintain a balance of my work, family, and community life until the fall of 2007. At that time began a series of events that continued through 2012 that led to the train wreck of my life. Those family events, deaths, practice chaos are in the hearing record to some extent. I won't go through those again, but I've been told that my depression began and was triggered in 2007, 2008. I realized that when I was doing this narrative, that for a lot of that period of time, I don't have clear memory of events. Now, addressing an earlier question, what did I do in my practice? My method of coping during this time was to compartmentalize, to keep my sanity. The dental office front desk duties, my legal work, family commitments, school activities, and my community activities that was routine could get done promptly and with a smile. Anything non-routine, troublesome, or requiring me to deal with irritable people got set aside in my to-do later stack. My misguided belief that I could do everything for everybody would not let me delegate the work to someone else or do a quick fix. Although I had every intention of working on the set-aside items when I could give it my full attention, that time seldom came. I've learned now that my inability to focus or concentrate were effects of the depression. I was often ill with what I thought was flu, extreme fatigue, and headaches. I was able during the day to be up for my clients or patients when I was working in the dental office, but then I'd come home and sleep for 12 hours. When the letters from the disciplinary office came, even though part of my brain said, I need to open this and I need to deal with it immediately, I didn't. My coping mechanism that I had developed to keep my sanity said, I'll do this tomorrow after I deal with this client or this issue, and I don't want to do it now because my secretary's here. I don't want to break down in front of her if it disturbs me, so they would sit. And I never did feel strong enough to open any of these letters until the intervention of Ann McDonald and KLAP. And then I took all the unopened envelopes to her office, and she opened them for me. At that time, in the depths of my depression, I could not even cope with opening the letters. Unfortunately, some of those letters were also letters from her office. They looked too official for me to even open those. So it was only by phone contact that I was finally put in contact with her. Lastly, why this won't happen again. 1, forewarned is forearmed. I know now that I had a physical malfunction in my brain with the neurotransmitters which interfered with my ability to work and prevented me from functioning normally. The medication is working, and I don't plan on quitting until my doctor says it's safe. I know now to be aware of events which may trigger my depression and anxiety and which coping skills work instead of avoidance. Number 2, I don't like being sick. I never liked being foggy-headed or unable to concentrate. I didn't like feeling tired all the time and wanting to sleep 12 hours. Now, once again, I'm able to laugh and dance and ride my bike, and I like smiling and joking with my clients and giving a smile and compliment in return. I'm not at a 100% yet. I still have work to go with Dr. Sedgwick in particular, but I've improved immensely since the hearing in January. Number 3, I love my clients and my practice. Of my current open files, not discounting the court-appointed sync cases, 22 of the 26 files are repeat clients. I'm doing updates to estate plans that I had done 10 years earlier, probate in a will that I wrote the original will for the deceased 10, 15 years ago. I'm doing corporations or real estate work for people that I did real estate work or corporations for earlier. Most of my new clients are referrals from current clients. These are my friends. This is a small town that I practice in. I see these people in the grocery store, at the restaurants, the church, post office, and bank. My goal as an attorney has always been to help people. I enjoy especially working with the elderly, helping them navigate legal issues, even just knowing the importance of having power of attorneys to deal with medical issues. The best moments in my life are the thank yous from those clients. My court appointments, sync and juvenile cases are very important to me. They're very much challenging, but I always hope that the court intervention and my representation will make a difference in these lives. And finally, and fourth of all, why this won't happen again is that I deeply appreciate the support that I've had from everyone, and I don't intend to let them down. Ann McDonald was the first to see my need and gave me support in facing those letters and advice on what to do next. She and the KLAP staff have been wonderful. Judge Patton gave me a nudge also, and I deeply appreciate his support. My therapists, Dr. Andrews and Dr. Sedgwick, have taught me coping skills and helped me sort out my feelings. The Topeka Resiliency Group has become like family. I will continue attending and hope that I can offer words of encouragement to new members as I was given by other members. Paul Klepper has been my practice supervisor. He's helped me get my practice back on track. Our weekly meetings have forced me to meet goals that we set together, and he has encouraged me in adopting new techniques. My husband and children have always been there with understanding, hugs, and words of advice. Now, that sounds like the ending to an Oscar speech, so I'll say thank you again for your time and attention, and I'm deeply sorry for the actions that brought me before you, and I hope you'll give me a chance to continue in my practice without suspension.
Thank you. Do you have any questions of the respondent or her counsel? Anyone? All right, thank you both.
Yeah, one. Was there any monetary aspect to this? Did the insurance company pay interest on that $30,000, and did anyone lose any money out of this deal?
Nothing was lost when the file was turned over to Mike Rowley, who had succeeded me as administrator. He was able to successfully get the life insurance policy, and they paid interest to the date the check was cut. I had failed to file an income tax return, and they were not able to get the refund that was due. Mike informed me of that by a letter, and I immediately turned around and wrote a check to him for the amount of the refund that the estate would have received. So and of course I never charged any fees of any sort for it, so there was no monetary loss at all caused by my delays in getting this case done.
Thank you.
Thank you for letting her go over. I think this is part of her recovery for her to do this today. Hang on, you can't leave till they let us leave.
Any further questions? All right, thank you both.
Thank you.
We had reserved 2 minutes for rebuttal.
The respondent just advised the court. Now she turned the file over to Mike Riley. Mike Riley, at the request of the district court judge some time ago, afforded her a lifeboat. If this were a product of a result of her depression and she couldn't handle this file, Mike Riley said, I will take it from you, and I will assume the responsibilities. I will take this file from you and get it off your desk. And the court appointed him successor administrator, and she did not turn the file over to him. The evidentiary, the items accepted by the panel hearing and in the record demonstrate his efforts to get the file from her. There is a letter from Mr. Riley to the respondent characterizing her conduct as unconscionable. And ultimately, he moved the court to rescind its order appointing him successor administrator, saying, I cannot do my job. Respondent ultimately provided the file to the court, but she did not turn the file over to Mike Riley to get this done, in spite of his efforts. You will not find, I made the argument at the panel that...
When did that happen? I'm sorry to interrupt you.
When did...
The failure to give the file over.
May of 2011, the court appointed Mike Riley successor administrator. And for a little over 6 months, he made efforts to get the file from the respondent, and ultimately advised the court that he could not assume the responsibilities because the file had not been turned over. So to characterize, I turned the file over to Mike Riley, and yeah, this all happened. There was no monetary damage. This family was waiting for years to get what I would characterize as a very simple estate closed. And the respondent had professionals in her area saying, I will help you. I will help you. I'll take that file from you. He offered in his letter to drive to her office to pick it up. And the respondent did not deliver the file to Mike Riley. I would submit to the court that this conduct was egregious. It remains inexplicable. And I would ask the court to determine that under our rules and under the appropriate sanction is a 1-year suspension. If there aren't any questions, then I'll withdraw.
Any further questions, counsel? Thank you, counsel. I thank you all for your remarks this morning. The court will take this matter under advisement. That concludes this morning's docket. The court is in recess until 9 o'clock tomorrow morning.